All right, our next guest at the second annual Family Law Mental Health Summit, a good friend of ours, and you heard him last year if you came, Ralph White, board certified attorney, AAML fellow, and ethics expert. Ralph, are you with us?
Yes, Eddie, how are you this morning?
I am fantastic, and thank you for joining us, and you look wonderful.
Try to look as good as the host, Eddie.
So we're going to do 30 ethics questions in 30 minutes. Are you ready?
I am ready, Eddie.
All right, I'm going to fire some questions at you and you're going to respond. Question number one, I have received a subpoena for a client's file from the Internal Revenue Service. What do I do?
Well, the confidentiality rule provides that with certain limited exceptions, a lawyer shall not reveal information relating to the representation of a client without the client's consent. Now, a lawyer's files, which obviously contain information relating to the representation of clients, are protected by the confidentiality rule. Therefore, absent consent from the affected client, a lawyer should voluntarily refuse to release a client's records to a third party. Now, once the lawyer is served with a subpoena, however, they issue changes from one of confidentiality to one of evidentiary attorney-client privilege. So there you have a lawyer's client's records. They're subject to a subpoena by a third party, and you should refuse to produce the records on the grounds of attorney-client privilege if the privilege might be possibly applicable. And then any doubts about the applicability of the privilege should be resolved in favor of non-disclosure of the records. So if a third party then obtains a court order requiring production, the lawyer may comply with the order and release the records as ordered.
2, may I charge interest on a past due account?
Yes, you can. There's no ethical prohibition against a lawyer charging a lawful rate of interest on liquidated fees or costs. A lawyer who wishes to charge interest on past due accounts, however, must do so either by 1, written agreement with the client, or 2, absent of a written agreement, by giving the client reasonable notice of intent to begin charging interest. And they've deemed that 60 days is reasonable notice to give to your client.
3, what is meant by the term of counsel?
An of counsel relationship is more than a mere referral arrangement. A lawyer may be considered of counsel if he or she has regular continuing relationship with a lawyer or a law firm in a capacity other than that of a partner or associate. Because of this close relationship, lawyers in an of counsel relationship are considered to be in the same firm for purposes of conflict of interest rules.
Number 4, I share office space with another lawyer. May we use letterhead that shows both of our names but disclaims that we are in a partnership?
No, you cannot. The rule prohibits lawyers from stating or implying that they practice in a partnership or other organization unless it is true. Therefore, in order for lawyers to practice under a name such as Smith and Jones, a bona fide partnership or professional association must exist. A statement that the lawyers are not a partnership could confuse or mislead the public.
5, a lawyer is leaving our firm. Which firm clients, if any, must be notified of that lawyer's departure?
The firm clients, whether they're brought into the firm by an associate or otherwise, for whom the associate rendered legal services, should be advised that that associate is leaving. The law firm and the departing lawyer must engage in bona fide negotiations for a joint letter from the firm and the departing lawyer advising those clients of the lawyer's departure from the firm. If the lawyer and the firm cannot reach an agreement on a joint letter, the departing lawyer and the firm may send a notice to the client stating that the lawyer has left the firm, asking the clients to indicate whether they wish to be represented by the firm, the departing lawyer, or another lawyer, and follow other requirements as specified in the rule. The bar has an informational packet, Eddie, entitled Notifying Clients of Change in Firm Composition. So if someone is going to leave your firm, the first thing a lawyer should do, if you're a partner in a firm or the head of your own firm, you should get your hands on that packet to make sure that you follow the bar rules.
It has a pretty good sample letter in there too, doesn't it?
Yes, it does.
RT question number 6. How long must I retain closed files?
Well, with the exception of trust accounting records, which you have to hold for 6 years, contingent fee contracts and closing statements in contingencies, that's 6 years. And the statement of insured clients' rights, you have to hold those for 6 years. There's no specified number of years for which lawyers are required to keep closed files. Similarly, there's no set time period after which closed files may be destroyed. The Ethics Committee has stated that the appropriate length of time to keep a file depends on what is in the file and the nature of the case. So the committee's established guidelines for lawyers who wish to dispose of closed files. The lawyer should first attempt to contact the client and obtain directions as to the disposition of the file. If the lawyer is unable to contact that client, the lawyer should review the client's file and remove any original documents or important papers, i.e. wills, contracts, etc., that may be later vital to that client's interest. And then any papers must be indexed or retained for a reasonable length of time. The lawyer may then dispose of the file, the remainder of the file, and if you're going to dispose of the file, you have to use reasonable care to make sure that you protect client confidentiality. So you just can't take the old file and throw it out in the dumpster. You probably should shred it or contact a shredding company and destroy the file that way.
RT, I'm holding money in my trust account, settlement proceeds that belongs to a client. Client hasn't contacted me and I have no idea about their whereabouts. What do I do with the funds in my trust account?
A lawyer holding trust funds for a missing client must make a diligent attempt to locate the client. While attempting to contact the client, the lawyer's trust account records must reflect that the funds are being held for a missing owner. If a diligent attempt to locate the missing owner is unsuccessful, the rule directs the lawyer to dispose of the funds pursuant to the procedure outlined in Florida statutes.
8, am I required to participate in the interest on trust accounts, the IOTA program?
The Florida Supreme Court has stated that all nominal or short-term funds belonging to clients or third persons which are placed in a trust account with any member of the Florida bar practicing from an office or other business location with the state of Florida shall be deposited into an interest-bearing IOTA trust account.
Number 9, several years ago, I represented a client in a residential real estate transaction. Now another client has asked me to represent her in suing my former client on a divorce matter. Ethically, what determines whether I can take the case against my former client?
Eddie, there's a three-pronged test that must be satisfied before a lawyer can represent someone whose interests are materially adverse to those of a former client. Unless the former client consents after consultation, the lawyer may not, 1, represent the present client in a matter that is the same as or substantially related to the matter on which the lawyer represented the former client. 2, use information relating to the representation of the former client to the disadvantage of the former client unless the information has become generally known. Or 3, discloses information relating to the former client's representation unless the rule allow or require disclosure. Contrary to what some lawyers believe, confidential information is not the sole test. All prongs must be satisfied. So using that scenario, assuming that it was just a standard real estate transaction, I don't necessarily believe that you could not represent the other party in the divorce.
Number 10, in settling a case for my client, the plaintiff, is it ethical for the attorney to agree not to represent any other clients in bringing similar suits against the defendant?
No, the rule prohibits a lawyer from offering or making any agreement in which restricts a lawyer's right to practice in part of a settlement of controversy between private parties.
Number 11, you're doing good so far, RT, by the way.
Am I keeping, I think we're keeping on track. I feel like at the end there's going to be like a bell that's going to go off.
I think after every right answer, we'll do a bell. We can add that in post-production. Number 11, I anticipate that I will need to testify on my client's behalf. May another lawyer in my firm represent the client at the trial in which I will testify?
Yes, under the present rule, only the testifying lawyer is disqualified for this reason. The rule expressly states that the remaining lawyers in the firm may represent the client at trial unless precluded from doing so for other conflict reasons.
Number 12, when must a fee contract be in writing?
Written fee agreements are required for all contingency fee contracts, not just personal injury and wrongful death. The rule states that any agreement to represent a client where the lawyer's compensation is to be dependent or contingent in whole or in part upon the successful prosecution of settlement of a matter must be in writing, signed by the client. Also, a client must consent in writing to agreements that limit the scope of representation of an attorney. And then finally, Eddie, agreements to follow the collaborative law process in family law matters also must be in writing with the client.
Ethics aside, what do you think about best practices for written fee agreements?
Certainly, your best practice is always to have a written fee agreement.
Question 13, how do I change my official bar name?
Well, this one comes up a lot in that lawyers leaving firms, whether they're associates or partners leaving, for some reason, people forget to go and change their information on the bar website, which you're required to keep updated. Now, when you have to change your name on the bar website because of maybe a divorce or marriage, the Florida Supreme Clerk's Office requires that you have to send a letter of the completed name change to the Supreme Court's office to change on the list of the roll of attorneys. You need to include your current bar name, and you need to give them your new bar name, which would include your first, middle, last names, and your Florida bar number. Surprisingly, according to the Florida bar, this is an issue.
Good to know.
That people aren't doing.
14, well, we're educating them, so that's what the purpose of this seminar is. 14, when can I disperse trust funds after depositing a check?
In general, a lawyer cannot disperse until trust funds are collected. Collected funds means funds deposited, finally settled, and credited to a lawyer's trust account. Now, a lawyer may disperse against uncollected funds in trust accounts only when one of the 6 enumerated exceptions applies. Although it's permissible to disperse funds under the 6 exceptions, disbursement against uncollected funds is not required. Disbursement against uncollected funds is at the risk of the lawyer who is still the guarantor, and the enumerated exceptions are if you have a certified check or a cashier's check, the check for the loan proceeds comes from a federal or state chartered bank or other institutional lender. If you have a bank check, official check, or money order and checks issued by a bank, credit union, or a savings and loan, any federal or state government checks, or a check on another Florida lawyer's trust account or the escrow account of a Florida licensed real estate broker. Under those exceptions, you can issue and disperse trust funds even though those aren't technically collected because they haven't been credited to your trust account. However, you're still on the hook because you're the guarantor.
Sure. Good to know, though. Next question, number 15. My client owes me fees. Grr. Can I sue him?
No, you can't, Eddie. A lawyer cannot sue a current client. In Florida Ethics Opinion, the committee stated that a lawyer cannot take action against the client to enforce a fee agreement before the representation is ended, either by withdrawal or by conclusion of the client's matter. The committee reasoned that suing a current client would create an impermissible conflict of interest between the attorney and the client.
Question 16. Can I give a second opinion to someone who is represented by counsel?
Yes, you can. A lawyer can provide a second opinion to someone who is represented by counsel concerning how that current lawyer is handling the case, and you may give information on the services the lawyer might provide. However, you need to be very careful that you should not solicit the person who is currently represented.
Number 17, can I call myself an expert or specialist if I'm not board certified?
Yes, you can. If you can objectively verify the claim based on your education, training, experience, or substantial involvement in the area of practice in which specialization or expertise is claimed.
And that's a pretty recent change to the rule, isn't it?
Yes, it is.
What if my qualifications don't meet that claim? What else can I advertise?
Well, if you practice only in certain fields or will not accept matters except in those fields, you're permitted to indicate that. You may also indicate that you only concentrate in or focus on or limit your practice to a particular area of law as long as those statements are true and accurate.
Question 18, can I charge my client back for fees I had to pay for the credit card service charge?
Yes, this is another recent change. A lawyer or law firm may accept payments under a credit plan, and lawyers may charge the clients the actual charge the credit plan imposes on the lawyer for the client's transaction. So, yes, you can charge your client back for the credit card fees, but you need to have that in writing.
It's good practice to throw it in the retainer agreement. 19, can I use a third party for cloud computing?
Yes, lawyers may use cloud computing if they take reasonable precautions to ensure that the confidential information of the client is maintained. Also, that the service provider maintains adequate security and that the lawyer has adequate access to the information stored remotely. It's incumbent upon the lawyer to research the service provider that they wish to use.
20, can I use targeted ads on social media to attract clients?
Yes, you can. Lawyers can deliver targeted ads through social media, but you must comply with the bar's more restrictive direct solicitation rules rather than the general advertising rules that are laid out by the Florida bar.
Question 21, what is a tombstone ad?
Surprisingly, Eddie, I didn't know what a tombstone ad was at first. When I was doing my research on what kind of questions should come up, do you know what a tombstone ad is?
I'm waiting to hear it.
Okay. So a tombstone ad is an advertisement that contains limited information that's listed in the rules regulating the Florida bar. It's things like your name, your address, your telephone number, your website address, whether or not you accept credit cards, prior legal positions you've held, positions you've held in the Florida bar on committees. These are the types of ads that do not need to be filed with the bar for review. So if you're just doing a generic tombstone ad, like I just said, you do not have to give those to the bar for review as if you were going to do, as we talked about before, maybe a more direct targeted ad. You'd have to run that by the bar to make sure that they clear it.
Let's say you have a standard regular ad. What are some things that maybe stood out that are likely to automatically have that ad rejected?
One of the simplest things that lawyers often fail to do is include their geographic disclosure by city, town, or county of place where they have a bona fide office. People tend to leave that off sometimes, and that is required in the advertisements.
What can a lawyer do if they have a bad review online and the person leaving the ad was never their client? Can the lawyer respond to the bad review?
Yes, they can. If it is really a situation where it clearly was not, they're clearly not a client of yours, that lawyer doesn't owe any type of duty of confidentiality to that person, so they can say that this is not a client of mine and pretty much leave it at that. If they were a client of yours, it's not in the rules, but the advisory and some of the opinions are that you should not engage in any way online in trying to dispute the bad review.
Number 20.
But if the person was not a client, you can respond and say this person was never a client of mine.
Proceed with caution. 24. If I refer to personal injury case, do I have to work on the case to get the referral fee?
Why the answer to the question is no, a lawyer cannot get a referral fee just for making a referral. Where a lawyer is not going to work on the case, the lawyer will be required to enter into a written agreement with the client and the other attorney where the lawyer assumes joint legal responsibility for the matter, agrees to be available for the consultation with the client, and the agreement discloses how much the fees will be shared between the lawyers.
Question 25. How about having a non-refundable fee agreement?
Yes, you can have a non-refundable fee agreement. And as I said before, that there's no requirement that a fee agreement be done in writing. The rules require that any non-refundable fee shall be confirmed in writing and explain the intent of the parties as to the nature of the amount and the amount of the non-refundable fee. One thing to note that if the client doesn't necessarily have to sign the writing explaining the non-refundable fee, it is sufficient for the lawyer to send a letter to the client that outlines the non-refundable fees. But your best practice is to get it in writing. If it's not in writing, you have to give the client sufficient notice in a letter that a portion of the fee or all the fee will be non-refundable.
Question 26. What is unit billing and can I do it?
Unit billing is a practice where an attorney bills a predetermined number of minutes for a given task. So for instance, maybe a standard motion to withdraw, your unit billing, you might say that's 0.3 or 0.4. So for every motion to withdraw that goes through the firm, we're going to bill 0.3 and 0.4. And no, you can't do it. And the reason you can't unit bill is that it fails to give regard to the actual time you spend on the true legal work, and it creates an excessive fee. So no unit billing.
Question 27. I did a great job for a client and she treated the whole office with a catered lunch from a really fine establishment. Is that okay?
Yes, Eddie. While it's okay for an attorney to accept small tokens, gifts, such as holiday gifts from clients, a lawyer should not accept substantial gifts from a client. I think you and your firm would be okay with a lunch from a nice restaurant that was given to you by a client. Now, if a client gives you a car, maybe that's a little excessive and not and above a small token gift or a box of cookies at the holiday time.
Question 28. What's the best way to handle when a client wants a family member or a friend to sit in on a meeting with their attorney?
Well, while the person may provide emotional support to the client, their presence at the conference destroys the attorney-client privilege. And if subpoenaed, this person and or the client may be compelled to testify as to what was said during the conference. So I will tell my client from the outset about the lack of privilege. I won't discuss anything other than basic generalities. I won't discuss strategy or anything that could hinder the client's case if the information was known by the adverse party. At some point, I will send the third party out of the room. So if they were ever deposed, they can testify that they sat in the first part of the meeting and was asked to leave and have no idea what I spoke to the client about, which typically would be more strategy and things one would want to keep confidential in a case. So they can sit in. You have to advise your client that you're breaking the attorney-client privilege, and then your best practice would be have that person, after some period of rapport or comfort level, have that third party leave, so then you can have a real heart-to-heart with your client and discuss things that you would want to keep confidential.
29. What are my CLE requirements?
Well, each bar member must complete a minimum of 33 credit hours of approved continuing legal education activity every 3 years. At least 5 of the 33 credits must be approved in legal ethics, professionalism, bias elimination, substance abuse, or mental illness awareness programs, with at least 1 of the hours in an approved professionalism program. That's a new addition, Eddie. They've added that professionalism program recently. So you have to make sure out of those 5 specialized in ethics, professionalism, bias elimination, substance abuse, and mental illness awareness, 1 of those programs, 1 hour must be professionalism. and at least 3 of the 33 credits must be approved in technology program as well. So just remember, if you complete more than 33 credit hours during any reporting cycle, the excess credits cannot be carried over to the next reporting cycle.
30. How do we stay out of trouble as attorneys?
All right, well, there are 6 easy ways, Eddie. Number 1, if it's not true, don't say it. Number 2, if it doesn't feel right, don't do it. Return your phone messages the same day as possible. Always take the high road. Always place the client's best legal interest before your pecuniary interest. And always be careful with your trust account.
Great words, RT. You got all 30 questions right.
Thank you. And I think I got them in right at maybe the 30-minute mark here. We're coming up.
Yep, we have just earned that half an hour of ethics CLE credit that is so important. So RT, thank you for joining us in the 2nd annual Family Law Mental Health Summit. And now we are going to switch things over to our keynote speakers, the president of the Florida Bar, Dory Foster Morales, and board certified attorney, Laura Davis Smith.